on the GoToWebinar control panel to allow all attendees to hear you. This system will notify you once you begin your broadcast. The broadcast is now starting. All attendees are in listen-only mode.
All right, we're going to get started in just a second. I want to make sure I have everything set up and the audio is on so that you can hear me. All right, so welcome. This is the Micklin Law Group's monthly webinar series. Today's topic is why every doctor needs a lawyer during a divorce. And while that may sound self-serving, because I'm a divorce attorney, and I believe that everybody needs a lawyer during a divorce, doctors have unique issues. By the way, you're going to hear my dogs in the background from time to time. Apologize for that, but I'm working from home, so I deal with these slight inconveniences. So like I was saying, I do believe everybody needs a divorce attorney. I got divorced many years ago, and I hired an attorney. I think people just need objectivity. But anyway, my name is Brad Micklin. I'm here to present this webinar for you today. I am an attorney licensed in New Jersey. I concentrate in men's and fathers' rights. My law firm is the Micklin Law Group at 187 Washington Avenue, Nutley, New Jersey. I've been practicing for about 25 years. I've been fortunate and honored to receive several awards that you see posted on my next screen. I don't present these to impress people, but to impress upon people of my experience and my dedication to the work that I do for my clients. I also serve from time to time as a legal consultant. I've been on Inside Edition. I've been on Politicking with the late Larry King, great guy, I-24 International, News, Fox, and many others. Again, just trying to give you background for those who have not worked with me and are considering working with me. I do take a great pride in what I do. I've been doing this a very long time. And as I mentioned, I concentrate on men's and fathers' rights, a micro niche that is not very common, but I believe it's best to serve a small group of people well than a large group of people average. So without further ado, let's jump into what a physician will need to know. And this works not only for the doctors that may be representing or hiring us, but I think also if you're the spouse of a physician, you may want to just listen sort of in reverse to what I'm suggesting. So that may also help you prepare. I say that because in my experience, and I may get a lot of flack from this, in my experience, let me stress that, I see more traditional families, and that's where I speak from. So I still see more men that are doctors and physicians. I see more women that are stay-at-home spouses raising children. I'm not saying good or bad, right or wrong. I'm not even saying that it's completely accurate. I'm saying it's what I see in my practice over the decades I've been doing it. So I speak from that standpoint. I don't want to offend anybody who's not included into that. I don't want to offend anybody who feels differently. I'm just trying to present the information in the manner most clearly to help the most amount of people. So with that caveat, let's go into what's probably the first and most important issue in dealing with any divorce, but especially if you're a physician getting divorced, and that would be custody and parenting time of your children. And when I speak from custody and parenting time, I'm generally speaking from sort of teenage and below. We will touch on college a bit and the unique issues that come with that, but parenting children in a divorced family on average gets easier as the children get older. So I'm generally thinking of younger children so that you can prepare for the issues that you're going to face. So the first thing I think physicians need to know is to build in flexibility to ensure that the demands of your career don't interfere with spending quality and frequent time with your children. So we always hope that parenting schedules are flexible. Most can do that. Not everybody can. Some people need a rigid schedule. In my experience, the doctors and physicians that I've represented often don't have the greatest ability to dictate their schedule, and they need to have flexibility to make changes. I generally recommend flexibility work both ways so that the other parent, the non-professional parent or the non-physician parent, I should say, also has the same flexibility. You always have to give and get. But the flexibility you want to have is to add or change your times. You want to try not to lose the amount of parenting time you have, but many think it's more important to have more frequent, more contact, or more constant contact than longer contact. So what that means is, a dinner on a Wednesday and a dinner on a Friday and a dinner on a Sunday may be just as good as having like one overnight, because you're getting more frequent contacts. But that may not always work. So additionally, you want to build in provisions for make-up parenting time. So if you're called away on an emergent issue and you lose a weekend, or you have to go away for a conference and you lose maybe a whole week, you want to have built in advance a way to make up that time. Now, again, in my experience, the best way to do that is to allow reciprocity to the other parent to have the same kind of flexibility, but he or she may or may not need that, but it's important that you try to incorporate that for yourself. Extended vacation time. This is obviously important for all parenting schedules, but again, for physicians and professionals, especially those that are running their own practice, may not always have the easiest vacation schedule. They may not always have a fixed time where they vacation, but you want to have it built in where you can have extended vacation time, especially if you are likely to miss out on some parenting time throughout the year because of the demands of your practice and of your business. One thing to also keep in mind for extended vacation time, and this really goes for anybody having vacation time with their children, and that is to consider whether or not child support will continue over vacation time. Now, I'm jumping ahead a lot because we'll talk about child support later, but depending on how long your vacation time is going to be, you could consider whether or not to suspend child support. Now, the guidelines, which we'll talk about, do not suspend child support for extended vacation time, which is customarily like a week or two, because the non-vacationing parent still has the expenses of the household and the utilities and the healthcare and things like that will continue even over vacation. But if for some reason you happen to have like a 3-week, 4-week vacation time in a block, or even over the course of a year, it is something you could consider doing, because you will be absorbing a lot of expenses if you have children over an extended period of time like that. Just food for thought, something to consider when you're building in your plan. So let's go to more custody and parenting issues, and let's talk about sort of the nitty-gritty day-to-day things. One thing I almost always recommend are provisions about what's called the right of first refusal, the ability to obtain your own child care without having the right of first refusal. Two separate issues. So the right of first refusal is really like a real estate term or a contract term, but we use it in family law to suggest that if one parent who is supposed to have the children doesn't have time for the children because of an obligation or a conflict, the other parent gets to have the right to have the children during that time. Meaning, if you're going away and you're supposed to have the children for the weekend, the other parent should be able to get the children for the weekend, as opposed to leaving them in some kind of daycare with a family member. Now, you may want to have that. You may want to have the right to obtain your own child care. That's something you need to consider. There are benefits to each circumstance. It is more common to have the right of first refusal and not to get your own child care during that. But you may want the flexibility. So for instance, if you have the children for the weekend, but you have a seminar on one of the days, you may want to have a family member, a friend, a babysitter, so that when you return, you'll have the balance of your parenting time. Now, you also may be able to get that with the right of first refusal by having the other spouse or the other parent agree. It's hard to say, but it is something you want to consider. So just remember the term right of first refusal. It is a very common term to incorporate into custody and parenting time. If you're a physician or a doctor that anticipates a lot of changes in your parenting time, or for some reason the other parent is likely to have a lot of changes in his or her parenting schedule, you want to consider whether or not you want the right of first refusal. The next thing to consider, and again, this is in all cases, but especially if you're going to have young children and a physician or doctor as one of the parents, and that is change of circumstances. And I do generally recommend for all of my clients, you want to contemplate how circumstances are going to change in your future and how that's going to impact your ability to spend time with your children. You may be building a practice, you may be in a specialty that is maybe popular or not popular in a moment, or your career is about to take a change that may change and increase your time in the years to come. You could be finishing a specialty, whatever the circumstance may be. You should look to see how the changes in your life will impact your ability to have your parenting time in the future. If you can identify things that will happen or changes that will occur and you can identify how that will impact, you may want to build that in now so that you don't need to go to court and prove a change of circumstances and file papers and get into a battle. If you can foresee it now, you should include it now. Along with that concept, if you do anticipate having to make changes or conflicts in the future, you want to consider a mandatory mediation provision, because, and you know what, actually I would throw in arbitration too, because the New Jersey law has now allowed arbiters to deal with custody issues. I recommend a mandatory mediation clause at a minimal. Arbitration is something you can consider, because, well, let me first tell you the difference in case it's not clear. Mediation is where you have a third person, could be a lawyer, could be a judge, could be a social worker, could be anybody that you want. That person is supposed to help facilitate your discussion and potential resolution of any conflict. I'm not a huge fan of mediation because many mediators that I've dealt with, while good-hearted and meaningful, they don't mediate in the way that I feel you're supposed to. So mediation is supposed to be the two of you to come to an agreement. The mediator is supposed to help you to reach that. That's very challenging in family law because of the emotion and the significance of the topics, like we're talking about your children and your precious time with them. It's not so easy to be patient and wait for the two of you to reach a reasonable accommodation of the other. So mediators often just tell you what it should be and suggest and point you in that direction. While that may be helpful for many, if not most, it's not how it's supposed to be. So I'm just not a fan of it being done that way. Nonetheless, I do still recommend it because it's much better than filing papers and going to court and taking months and thousands of dollars to get to the same end. Arbitration, I am a big fan of because it's a binding decision. You put your information to the arbiter, again, who can be a lawyer, a judge, a social worker, or anybody that you feel is competent. Actually, you know what? I don't know if it can be anybody that you feel is competent, but I guess it could be because you'd be coming to an agreement afterwards that would be binding. But I generally use only lawyers and retired judges because I think you're going to get better and more well-thought decisions. But nonetheless, arbitration is something you can consider. I've never seen a binding or a mandatory arbitration clause that may be a little restrictive because you do give up some significant rights in arbitration. I'm not going to go into them at length here, but I've done webinars that you can find on my website, micklinlawgroup.com, as well as my YouTube page, just Brad Micklin at YouTube, and you'll see I've done webinars on all these topics actually in smaller versions, but I've definitely handled several in mediation and arbitration, explaining the differences and my thoughts about them. All right, so let's wrap up custody and parenting time and move to what is often the next most significant, well, probably not the next most, but another significant issue in divorces, and that is navigating the division of your, and I say substantial assets, I don't want to be biased and suggest that all doctors are making a lot of money and have substantial interest, but this webinar is geared towards that type of practice, geared towards what I'm assuming to be, and I guess I should have said this in the beginning, this webinar is with the concept of being a moderate to long-term marriage with young but not infant children, so that you will likely have acquired assets and there may be alimony considerations, which we'll talk about in a minute. But so when I say substantial assets, again, I'm not trying to be prejudicial or biased to doctors or professionals, but this is kind of the background that I prepared this webinar. So first thing you need to consider when you're talking about assets is the appraisals and valuing them. So you can either get a joint appraisal, which is you and your other spouse together, and you have one opinion or one appraiser, or each of you can get your own appraiser. You can also have a joint appraiser that's appointed by the court, but it's really not much different than just having your own joint appraiser. So there's obviously a lot of considerations to how you want to do this and which one is better. And, there's no one answer to that. Generally speaking, if you have an accommodating spouse as opposed to a potential high conflict case, I think that will change whether or not you should do a joint or an individual. So if you have a reasonable spouse, if there's good accommodation and communication, then you can do a joint appraiser. It's faster and obviously less expensive than having two. The problem is you become bound to that. Joint is good because you are not bound by that. If you get an adverse appraiser or an adverse result, you each still reserve the right to obtain your own individual. But the point of starting with a joint is either to facilitate the litigation by getting one opinion and keep the cost down. Sometimes it's also being done to preserve your right to get a second bite at the apple. But from my standpoint, you get a joint if you are looking to streamline litigation. Individual appraisers, again, you have the right to get your own. If you've done a joint, it does cost more and take longer. But if you're starting from individual appraisers, that, again, depending on your circumstance, may be a good or bad decision. It's good in that you get your opinions and you move forward on the litigation. The bad is you're bound by that. If you get an appraiser and you get an adverse report or evaluation, you're kind of, I was going to say married to that, but with no pun intended. Now, in some circumstances, you can seek to get another appraiser before you exchange that report, but you're likely to be required to disclose the fact that you had a different appraisal that you're not relying upon, and you're likely to have to present that to the other side. So it's going to impact the credibility of your subsequent decisions for appraisers, because it's going to look like you went shopping for the best number, which you are, but you don't want it to be laid out in your paperwork that way. The next issue that we'll turn to when it comes to evaluating assets is comparative market analyses. This is generally for real estate. While an actual appraiser or appraisal is always best option, some people elect to get a comparative market analysis, a comp analysis they're referred to by agents and people in the real estate business. And that's a less formal evaluation of real estate based on other properties of a similar makeup that have sold recently. It's very common in residential. You could do it in commercial. The problem in commercial is it's harder to find comparable properties in the same locale. Meaning, if you own your home, the chances are that homes in your same street and town are very similar to yours. So a comp for a house that's sold next door to you is going to be very helpful. If you own a multi-unit residential complex in Hoboken, it may be hard to find one that's similar to yours in Hoboken that sold recently. So it's more common for residential real estate, but it is certainly available for commercial. Next, assets. There will often be pension and retirement accounts. These are not as difficult to appraise. First, simply speaking, there's two types of accounts when it comes to pension and retirements. One is sort of what I'll call a cash-based account. Its value is based on the assets in the account. Another is based on maybe longevity or term, how long you've been working with the company. There are companies that will appraise both types of accounts if need be. If it's like a cash account, like a 401k, for instance, it's really just a division and a rollover for tax purposes, which I'm not also going to go into in depth here. If it's more complex than that, or there are premarital interests. There are companies that we as divorce attorneys use to help analyze and divide, as well as rolling over and transferring the documents necessary to handle pension and retirement accounts. Next, in a lot of cases, you'll have valuable personal property, artwork, collection, precious metals, which could be just collections or assets. I've had a case recently where one of their greatest assets was a gold collection that they had acquired over the years. You want to figure out what you have, how you're going to get it appraised. And along with this, you want to take inventories of the property. You can also have it marshaled and held somewhere for safekeeping, like we did with the coins, because they're easy to throw in your pocket and all of a sudden they disappear. In cases of valuable assets, especially if there's going to be storage or transportation, I usually recommend a former law enforcement agent. A lot of courts and judges have people that they can recommend. If you are dealing with a divorce practitioner that's been around for a while, he or she too will have people usually that you can count on. But it's something you should consider, and it's also very helpful in keeping the conflict and potential problems of a divorce at a minimum. Next, when we're talking about assets, is if you have a medical practice that you need to be evaluated. And again, there's going to be possibly premarital interest, as well as marital interests. First thing that you want to do is talk to your lawyer early in the process to find a forensic accountant that's a good fit for you, your staff, and your attorney. Evaluating a medical practice, or evaluating any business, but a medical practice even more specifically, because the issues that we'll talk about in a second that are unique to this kind of practice are very important. They're very difficult. And because you don't want, as the physician, to have your divorce and the strain and difficulty that it could be impact your ability to run your practice, impact your staff members. When you have, you may have two different lawyers making phone calls, you may have accountants coming in to review documents. You want to make sure that the people that you're working with are going to work well with you and your staff, because you want to make sure that your staff is able to handle it. You don't want them to get nervous about their job or the strength of your practice. You certainly don't want to scare away any patients or potential purchasers. If you're actually looking to sell your practice now in the future, you may also have other partners that you're working with. So the point is that take all this into consideration early so that you can make sure the people you're working with are good fits for all the people that are involved. Another thing I often recommend to the doctors I represent is finding a staff member that you, if you can, that you trust to be sort of your go-between person for your attorney, for your forensics. It takes the burden off of the practitioner. You can't be, depending on the nature of your practice, if you're going into a surgery, the last thing you want on your mind is anything about your divorce. You're meeting with patients. The last thing you want is anything about your divorce on your mind. You want to be able to focus on your practice, keep it running, and let it and you survive through this. So having a trusted staff member that can take some of this burden off of you will help a great deal as you go through this process. All right, so let's go a little more about appraisal of medical practice. Some of the tips that you want to do, whether you're watching this now, if you're in a divorce or if you have one contemplating in your near future, you always want to first organize your records in advance. Doctors and professionals are often very good at what they do. That doesn't mean they're good business owners or businessmen. Many are and many aren't. It's the nature with any profession. So make sure that your records are organized so that when people do come knocking on your door for evaluations or for questions or for discovery, you're not fishing to grab it and put it all together and delaying things. You have it, it's ready to go, you've reviewed it so that it's in its perfect form. You want to provide the information and documents to the business early on, and that is to your attorney or to your appraisers. Don't be in such a rush to turn it over to the other side. Let your lawyer guide you on how that is to be done, but you want your people to have it in hand as fast as possible. Next, most important for doctors is to consider the need for non-disclosure confidentiality agreements and absolutely make sure that you are in strict compliance with HIPAA and your doctor-patient privilege requirements. Now, I have never represented a doctor that had any less than the best understanding of his obligations for his clients or his patients and his practice. But you need to make sure when you start handing over information to other people, like your staff members, like your forensic accountants and your attorney, that these have been considered. You, more often than not, need a protective order signed by all the people that will be touching these documents. Your professionals, your lawyer, your accountant, the court, the other party. So need to make sure that this is contemplated and done in advance before anything leaves your office. Now, moving on, while we're still talking about medical practice, some of the things that you want to consider as far as its valuation is going to be. First is ask your attorney about momentum of marriage to minimize exposure to equitable distribution claims. What that means is the value of a business in divorce will often be valued by the change over the course of your marriage. So let's say you opened your practice 5 years before you got married and you're married for 10 years and your business quadrupled over the course of your marriage. Many will argue that that was the momentum during the 10 years of your marriage, where it may have been the first 5 that really built your office and where it really took off. So the momentum of marriage is what judges rely upon to make sure the other spouse gets the best or fair share of the business evaluation. That may not, in fact, be the right analysis. So if you are going to have a business that was premarital, you want to start contemplating what you're going to need to do to establish that value and how that value, the premarital value, was the momentum that caused the significant increase during your marriage and not necessarily the contribution of the other spouse. And I'm not saying that this is a bright line for all cases. It may have been the contribution of the other spouse that allowed the practice to take off. Many practitioners, physicians agree and want their spouse to share in that momentum, that increase in value, but on average, in my experience, most don't. Physicians and spouses alike don't want often to part with their assets in a divorce. They don't usually want to pay alimony, which we'll talk about in a moment. So when I'm talking about that, and I don't want to sound like I'm trying to suggest, stick it to your spouse and don't give him or her the fair share because even though they helped you grow the business, I'm saying look at it and make a determination. If it was the marital contribution that increased the value, the momentum of your marriage, then your spouse should share in that. If it was the premarital business that really just grew over time, then he or she shouldn't. So along those lines, you want to ask your attorney what's going to help you minimize that claim if it is, in fact, your position that it should be minimized. You want to discuss early on the level of detail needed for the appraisal and throughout all the phases of your discovery. So, and another issue that I won't go into at depth, I did another webinar on how business are evaluated in divorces. But the law, let me just say, is very archaic in valuation of practices. It does not adjust for lack of marketability, meaning if you're just a one-man shop and nobody would buy it from you unless you ran it, there's no adjustment. If you owned a small share of a big practice that you can't really sell, so there's no marketability for it, there's no discount for that. So the principles that would normally govern what we call arm's length sale of a business, when you're just selling yours to some other person, some investor, another doctor, whatever it may be, don't always apply in a divorce. So in many cases, the valuation of your share is going to be much greater than it realistically is, and you may need to buy that out. So you want to work to minimize that, and that's what these topics are all geared towards helping advise you about. Now let's turn on to the other probably most dreaded topic in divorce, and that is alimony and what's called pene lite support. And pene lite just means temporary or while the matter's pending. So I always talk about temporary alimony and permanent alimony. And when I say permanent alimony, I don't mean you're paying it forever. I mean it's after the divorce. So actually, I should call it final alimony. Temporary during the case, and final, that's after the case. But it doesn't refer or relate to the length of the payment it's going to be. So let's talk about issues with pene lite support and alimony. The first, and again, as I said in the beginning, my practice and the clients that I see, especially the doctors I see, are more often traditional. So there is one person running the practice and one person staying home raising the children, or at least that person may be working in the practice to keep the books and work with patient relations, but not necessarily a full-time job. So the first topic that a traditional physician needs to consider is imputation of income to the spouse. So anybody, not anybody, but most people in a divorce are going to be considered to have the ability to earn some level of income, whether or not they have education, whether or not they have work experience, regardless of their age, they're going to have some level to earn. Now, that's going to be drastically different on a case-by-case basis. So the first thing you need to do is realize that this is an issue and start investigating it with your attorney. The most important issue inside of that consideration is an employability expert for that spouse. You can't go in and say, I think he or she can make this much money. You can't go and say the Department of Labor stats tell me that he or she can make this kind of money. You can't even say necessarily they made it in the past, so they're going to make it again. That may not necessarily be true. An employability expert is somebody who will come in, will administer certain tests, measure capabilities, and give a report and an evaluation of what potential earnings that spouse could receive. That is going to be crucial in minimizing your alimony. Now, one thing you can consider, because employability, as with all experts in a divorce, can be costly, and a divorce with a physician, especially if there's a private practice, is often very expensive. Sometimes I try to reach an agreement on what imputation of income will be. It's not that hard to truthfully figure out how much a spouse is likely to earn when he or she enters the workforce. We look at, again, past experience, past education, the marketplace, parenting responsibilities, and you can get a sense whether they're going to make $25,000 or $125,000. So sometimes it saves time and money to sit down and figure out what do we think it really would be and make an agreement to that. Because that's not the only issue when it comes to alimony. There's at least 14 different criteria. Again, far too in depth to go into in this webinar. And I hate to sound like a broken record, but go to micklinlawgroup.com or Brad Micklin on YouTube, and you'll find countless webinars and other videos. And also on my website, you'll have blogs if you are more inclined to be reading than watching something, all about alimony and pene lite supports and calculations and child supports. It's all there in a much more in-depth form. So after you've considered imputation and employability, you next want to consider some of the issues that are going to come out in your pene lite support or while your matter's pending. First is, you may be in a divorce for 1 or 2 years. Few go longer than that. Few are shorter than that. There are requirements the administrative offices impose upon judges to move cases expeditiously. That doesn't always work. And when you have issues like real estate evaluations, business evaluations, employability experts, it's just sometimes hard to get it done inside of that time. So your temporary support, your pene lite support, may run for a long period of time. I always ask for certain things to be granted in the beginning, whether we're doing this by an agreement and setting temporary support, or if we are going to court and the judge is deciding it. First is mandatory job searches. I never want the spouse who's receiving support from my client to be able to sit back and not do anything for a year or two. You want them to be able to prove and present the efforts that they've been making to get jobs. First, it'll show that they're taking responsibility and looking for a job. It'll also give you a sense of what jobs are available and what is the likelihood that he or she will obtain one of these, so that you have a sense for the needs for alimony that will later be decided either between the two spouses and the attorneys or by a court after a trial. Another thing I always want to get is a trigger for automatic review of support. Again, this may be sitting for a year or two and nothing's happening. Your business could take a dive. I mean, look, this is being recorded May of 2022. We're slowly emerging out of the COVID quarantine restrictions and issues. We all had a big wake up that the world can change in ways that are not foreseeable, and that can happen to your practice. In my experience, I know a lot of successful physicians and business owners who believe that they're always going to be successful because they always have been successful. And while we always hope for that, it's not always the case, and you need to be able to plan that it may not be. So you want to be able to review support. You also want to have the other spouse have an obligation to, be planning for the future, along with the mandatory job searches. If support can be adjusted, if they don't comply with that or they don't show a genuine effort to get a job, they'll make a better effort to get a job, and then it's better for everybody involved. Another issue for both pendentia lite and final alimony is cohabitation. There's often cohabitation during a divorce. Sometimes it's because partners have moved on and entered new relationships. Sometimes it's because of financial need. They move in with a partner, they move in with a friend, they move in with family members. This is going to impact their need, and it may impact the support you're paying, both good or bad. Usually it's for the better for you. So you want to make sure that you're watching for cohabitation. You want to make sure there's provisions that prevent it. And if it does occur during your payment, whether it's pendentia lite during the case or final after your case, you want to have cohabitation as a trigger to review and or modify. Now, you may find this out by having a private investigator. That's a tricky topic. That, there are some issues about, first of all, like with GPS devices and things like that, stay away from it. It is often can be considered unlawful in some circumstances, and in many circumstances, it can be considered domestic violence. So sometimes having a private investigator do this takes that risk off of the client, because the client's not the one doing it. It's the private investigator doing it, and they have a different purpose for seeking this information as opposed to a spouse who's planning a GPS in the car. So speak to private investigators, speak to your attorney if cohabitation is likely to be an issue, and this is a method that you plan to attack it from. You want to make sure that you do it properly and in no way that it compromises your case. All right, moving along. Some considerations when you're looking towards negotiation, which, believe it or not, most divorces are resolved in that way. Everybody thinks they're dropped down ugly court battles. Most of them are not. They're settled at a table with a couple lawyers and some negotiation. But one thing you want to find out, and this goes back to the earlier part of this webinar where we talked about the division of assets, you want to be sure to avoid a double dip between alimony and equitable distribution. And what that means is, if your spouse is going to be taking substantial assets and generating substantial interest income, investment income, you want to make sure that you understand how that impacts the calculation for alimony now and in your future, depending on the length that you will be paying and the amount. But you want to make sure that you understand the relationship between the assets and the investment or the income from the assets that they're going to receive, as well as the alimony that you're going to pay. Another thing to consider when discussing alimony with your attorney is whether or not there's a buyout of alimony. In some circumstances, it's good. In others, it's not. A lot of people that I deal with, especially the physicians I dealt with, come from a position of not wanting to have anything to do with their spouse afterwards for whatever the reason is. And they want to just give a lump sum of money and be done with it. And that's good in the sense that you're usually getting a reduced value because they're getting the present use of the money and the future interest of the money. So you're going to pay slightly less, or not, so I shouldn't say slightly. You're going to pay less, whether it's slightly or significantly, which is a good thing. The bad thing is, one of the bad things is if the spouse should unfortunately pass or remarry the day after you make this lump sum payment, you don't get any of it back, which is likely to be different if you were paying a traditional alimony payment over a period of time. So these are the kind of considerations you want to consider and discuss with your attorney to figure out which is best for your circumstances, and make sure that you're just well informed of all of these aspects. Now, the next support issue to look at is child support in college. So child support and college support are fundamentally different in New Jersey. And they can often be different fundamentally for a doctor or physician practice type of divorce. So first, to understand, New Jersey has a child support guidelines, which determines, based on several factors, but largely the combined income and New Jersey's belief of how much that income is needed to support a child. You plug the incomes into this child support guidelines and you get a fixed number that gets paid for child support. Now, the New Jersey child support guidelines go to a combined net of, I think it's $187,000. In many, if not most, divorce cases that I've had that involve a doctor or a physician, they are beyond that $187,000 gross. So in those cases, New Jersey has what's called a high income addition, which is, we run the child support guidelines and we see the cap ceiling of the number. You plug in the full income, but it only gives you up to what would normally be the 187. Now we have to figure out, based on the needs of the child now in the future, how much more should be added on top of the child support amount to make sure the child's needs are going to be met. Now, in here, I make a mention to the Strahan case, Mike Strahan, where they said a child doesn't need 3 ponies. And what that means is, if you're making $10 million, it doesn't mean that your child support should be $1 million or $10 million. It doesn't mean your child support should be $1 million. It doesn't mean that a child needs to have every benefit because of a high income earning family. There's a level or a cap where it's excess. So what the courts do to determine this is they look at the underlying child support custody factors. So again, another topic I can't go into because it's too lengthy. And again, go to my website, micklinlawgroup.com, or my YouTube, Brad Micklin, and you'll get webinars on child custody factors. They go through the child custody factors to determine what special needs or abilities or education the child has and will have in the future, and build in what would be an extra payment to meet these needs. Now that's important. So along those lines, always speak to your attorney regarding that, because the important thing when it comes to high income addition is you need to make sure that you understand what needs are being factored into this high income, because as the needs change, your support's going to change, may increase or decrease. You know, if you have a child with a special propensity in an area or special talent or a medical issue, you're going to be paying extra to meet those needs. If the child loses interest in that hobby or goes in a different direction, or his or her health improves, those expenses are no longer going to be incurred. You want to be able, if you feel the need to change the support level and eliminate those expenses. Conversely, as a new need or arises, you may need to review and add to support. So you want to make sure that you're clear what's going into it and what may be added to it later. And you only can get that largely from speaking to your lawyer. So consult with him or her before that. Other issues around child support. We talked a little bit about modification when it comes to parenting time, but modification of support obligations and reunification counseling are just a lot of issues to touch on. Again, there's often, in my experience, been physicians that have a hectic work schedule. They're often absent or had been in for a period of time. A lot of times when they get divorced, the other spouse starts to alienate a child, intentionally or unintentionally. I'm not here to accuse. I'm not here to throw out the buzzword about alienation, but it does happen. Like I said, sometimes it's intentional, sometimes it's not, but it does happen. You want to be prepared for counseling and experts that can assist you if that does happen. It could have happened even while you were married. If you were busy building your practice, strengthening your profession and your skills, you may have had to put your family on hold with the goal of having time later in life, and then the divorce came up and changed those plans. So just be aware that, like I said early in the beginning when it came to parenting time, think about what's going to happen in your future, what changes may occur financially for you and your children. Build in provisions about modification. If you have been or expect to have problems with spending time with your children, or if you have a spouse that may frustrate that, talk to your attorney about reunification, counseling, and therapy, as well as experts for that. All right, now along with college support with child support is college contribution. So, and a lot of families have started their college contribution before getting divorced, and they may have 529 or other college savings set up. That will usually always be maintained for the children's benefit. But if you're going to be talking about contribution after the divorce, either put it into your own separate 529 or own separate college savings, because in some cases, well, not saying the reason to have it is so that you can make sure that your post-divorce contributions are considered your contributions for college. So I had a case that came to me post-judgment, meaning after the divorce was over, where they agreed to continue to contribute to the 529. The physician that I was representing had been contributing significantly more, and there was an ambiguity there was a perceived ambiguity to the divorce settlement as to whether or not the doctor was going to get credit for the entire contribution or whether or not that was going to be put on top, divided equally, and then they would contribute afterwards. So fortunately, it was resolved favorably in our side that the excess contributions counted towards the doctor's contributions, and it didn't get divided equally, where he would have to then contribute more. But that doesn't mean it's always going to work like that. So you want to make sure to address it in your resolution or at the trial court level, and keep your post-divorce contributions separate. The next issue for college and support issues is what in New Jersey is called the Rutgers Rule, and also graduate school contribution we'll touch on at the same time. So Rutgers Rule is basically saying that I'm agreeing to limit the Rutgers Rule is child could go to college at anywhere, but your contribution is limited to what it would be if they went to Rutgers or a state school. So even if they go to Harvard and they're spending 5 times the amount, you can agree in advance that your contribution is going to be limited to what it would have been if they went to a state school. That's not always 100%. I mean, I hate to say that your agreement may not actually hold up when I always advocate for resolving a divorce, but agreements for children are always subject to review by the courts now and in the future. So if you make an agreement that's going to harm your children in the future, courts are going to change it. And I say that with regard to the Rutgers Rule because in your average divorce, and I'll say average just for lack of a better phrase, you have usually modest incomes, you may have modest levels of education, and the courts are not likely to overturn an agreement that says I'm only going to contribute to a Rutgers level, because that's what I would have done if we were together. Now, if you're a high income physician case and you agree and you make an agreement that says you're going to limit your contribution, even though your children may have the ability to go to a much better school, courts are likely, in my opinion, to change that or to modify it. Now, it's not hard and fast that a court will, but just be prepared. So if you are going to make that kind of limitation, make sure you have very clear, specific language about why it's being done, the changes that you're making, the concessions that you're providing for that agreement so that it is less subject to modification by a court later. Now, when it comes to grad school contribution, I threw this in because in most cases, a parent doesn't have to worry about being court ordered to contribute to graduate school. Albeit, as a caveat, the lead case Newberg versus Rico in New Jersey, that discusses the child support of a college-bound child, was actually a graduate school case, but it's never been used, to my knowledge. Oh, actually, one time it was used to support contributing to a grad school program. That was a unique circumstance. It wasn't my case. I just knew the judge who did it. I've never seen it since then, but just be aware, because a physician will have obviously had significant grad school education, so it's foreseeable a judge would think that he or she would want the same for his or her child. Another thing when it comes to college contribution, and this really is applicable to all cases, but physicians do need to also be mindful, is adjusting child support when the child goes to college. So it doesn't mean child support's eliminated because you're paying for college. You sometimes pay for both, not sometimes, usually pay for both. But the child support that was set by the guidelines with the high income edition that we were talking about usually gets modified, but not eliminated. It's modified because some of the expenses that were being paid for the child are being paid through college, like room and board, food, but the custodial parent still has expenses that they're incurring for the children or child, like keeping a room for them. They're keeping the same home, so their mortgage or rent payment remains the same. Their utilities are the same. They're still providing health care. So there's usually going to be a child support component and a college contribution component. But the point to be is that child support can and should be modified downward, usually when a child goes to college. And then other things to look at for college contribution support are what I call the extras: automobile, car insurance, cell phones, preparatory classes, computers, iPads, whatever may or may not be foreseeable. You want to sit down and think about it and decide, are you agreeing in advance to contribute to it or not? Because you don't want to wait until later when you've agreed to a child support amount, you've agreed to a high income edition, and you've already agreed to college, for instance, or you've been ordered, and now all these things come up, and now you have to address whether you can pay it or not. And sometimes you don't have the choice. Sometimes you're going to be ordered to do it. So contemplate it at the divorce level. Contemplate it when you're discussing parenting time and child support, so that it's likely to be upheld later when you are post-divorce and actually addressing the issues of a child going to college. Next, let's talk about some issues that you'll need to deal with your attorneys and other experts on a more personal level when getting divorced. And, I hate to say it, because divorces are often very difficult and can be challenging and traumatic in some cases. But one of the first things you need to consider when you're getting divorced is estate planning. If you are a prominent or successful physician and you have a practice and you have assets, you want to have a new will drawn up as soon as possible, even before you get divorced. I recommend that, so that under New Jersey law, what would normally happen is if you're contemplating divorce, what your will says happens. So you may leave all your assets to your spouse. You can draft a will before getting divorced that says differently. It could possibly exclude your spouse. Now, again, another topic I can't go into at length. And again, go to my website, micklinlawgroup.com, or YouTube, Brad Micklin, and go through some of my estate planning webinars. But if you draft a will while you're married saying my spouse gets nothing, that's not necessarily going to be the outcome, but it will still limit what your spouse may get. You would also get some advice on how to structure the assets to remove them from your estate or from what's called probate, so that your spouse would get less. And also know that when you file a divorce, the law, meaning the concept of the law, it revokes the will that you had. So at that moment of divorce filing, you technically don't have a will, which means that your spouse may or may not get everything. And you may not want that. You most likely don't want that. Even if you want it to go to your children and you think it's going to go to your spouse and then your children, that may not be the case. Spouse may remarry, your spouse may decide your children don't need that. Maybe, your spouse wants them to work harder and have more skin in the game. But nonetheless, just know when a divorce is filed, you don't have a will. You should draft one at that time of filing. You may want to draft one at the time of final resolution, because the asset structure will likely have changed But nonetheless, estate planning is a crucial issue to discuss with your lawyer the day after you retain him or her in a divorce if you're a physician and you have substantial assets. Now, again, the next topic, first talk about death, now we talk about taxes. The two certainties in our life. You always want to consult with an accountant for tax implications of your support and equitable distribution settlements, both for current and future. Now, your divorce attorney should be able to help you with these topics, give you some general guidance about when and where and how alimony is or is not taxable, the tax consequence of the transfer of your assets and things like that. But a divorce attorney cannot give absolute tax advice. They're not a tax attorney, unless they're a tax attorney. But most of the time, they're not going to be as well versed in taxes as a tax lawyer would be or as an accountant. So you certainly want to speak to a professional tax attorney or accountant for that advice. Next, again, as I kind of sprinkled throughout this, a physician going through a difficult divorce is going to have a lot of challenges, and because of the need to make sure mental capability stays strong and you treat your patients well, I always recommend talking to some mental health, get a therapist, talk to a counselor. Obviously, it's confidential. Look, I think everybody going through a divorce, if it's a difficult divorce, I guess there's really little easy divorces for most people given what you're going through. So I would say talk to a therapist, go to a counselor, at least have one set up that you have interviewed and took some time, so that if you don't think you need it right off the bat, but later find you need one, at least you have one. You don't have to start the search now. Speak to a lot of lawyers before and during your case. In my opinion, lawyers are usually very flexible. We try to be convenient and helpful to our clients. We do understand the nature of the difficulty. Now that we're, emerging from COVID, there's been a lot of changes. Now we have virtual meetings and things that were less disruptive to a schedule that we didn't have years in the past. And in my experience, both with my clients and other lawyers, I know we do try to help our clients as most. But while they call us counselors at law, we're not counselors for mental health issues. So there's really just so much we can do for you that you might want to make sure you have some other people in your corner. That is the end of it. Normally, I'd be taking questions that can be posted into the chat panel on the bottom, which when signed in, you would have received some instructions, but I don't see any questions, so I'm going to assume that there aren't any. My email, unfortunately, is not on this slide, so I'll have to have that changed. But my email is brad@micklinlawgroup.com, which is M as in Michael, I, C as in cat, K as in kite, L as in Larry, I as in island, N as in Nancy, lawgroup, LAWGROUP.com. If you have questions about this, feel free to email them to me. I will do my best to address them. Please note that emailing a question does not create an attorney-client relationship. While the information is always going to remain confidential, because that's just how I preserve information from contacts, it does not prevent me from possibly being involved in your case on the other side. So don't email me with the hopes that it'll bar me from representing the other spouse, because we will not be answering that as your attorney. We'll just be providing you some information. And as I said, probably too many times throughout this, you can also go to my website, MicklinLawGroup.com, and my YouTube page, Brad Micklin, for other topics and videos related to this information, as well as others on divorce and family law. With that, I thank you for tuning in. I hope this information helps you, and I wish you the best of luck. Stay safe.